mbali nami. Ukweli ni kuwa uliposema hutaniacha kamwe, hivyo tu ndivyo unavyotenda. Na hulali pia waniwaza. Baba, nipe uvumilivu, uvumilivu. Baba, nipe uvumilivu, uvumilivu. Siku zangu zote nikungoje. Uvumilivu, uvumilivu, uvumilivu. Yesu, nitakungoja Yesu, nitakungoja, 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 ninakungoja Yesu, ninakungoja, 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 nitakungoja Yesu, nitakungoja, 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 ninakungoja Yesu, ninakungoja, 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 ninakungoja Yesu, nitakungoja, 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 Baba.
A very good afternoon to you, our viewers. Karibu sana to Midweek Vibes this week. As usual, very excited as a team to be coming live to you as we go through another pertinent topic today on will writing, the importance of will writing. And so we'll be generally going through the aspects of will writing. Why is it important? And we have, again, as usual, amazing people to take us through this process. My name is Jasmine Wangai, and I am excited to be here. And I'd like to introduce the team for today, and I can start from my left. My right.
Depends, are you left-handed or right-handed?
I am right-handed. Yes, karibu sana.
Thank you, Jasmine. My name is Eunice Njoroge, and I have the honor of passing on the mic to the gentleman on my right
Yes.
to introduce himself, tell us who you are, what you do. Are you a member of the church? Where do you fellowship? And are you married? Do you have children?
Thank you, Eunice. My name is Jerry Gitonga. I am a lawyer. I work as a general counsel for the newest TV station in town called, in Kenya actually, called Akili Kids TV. I am a congregant of this church, and I fellowship at the Mamlaka Hill Chapel, Mamlaka Hill Road. It's called what? City Campus. Yes.
Karibu sana.
And yes, I am married, and we are blessed with 2 boys.
Thank you, thank you.
Karibu sana.
And on our left, Karibu Sana.
Yeah, thank you so much. Ruth Kibebo. I practice in my own farm with that name, Kibebo and Company. And no, I'm not married. And yes, I fellowship in Mamlaka Hill Chapel, Rwaka. Thank you.
Karibuni.
Wow, thank you so much, and we are grateful to God that He has put resources right in the church that we can tap into, and we thank you that you have spared your time to come and be with us in this day as we try and dip deeper in this important topic that Jasmine has talked about, and we'll go right deep into it. And maybe Jerry, you can start us off. We hear about will, we've heard about will all our life. How would you explain to a layman what a will is in very simple terms before I come to you, Ruth?
Okay, thank you. When we talk about wills, we are looking at that whole area of, in the law it's called estate planning. So having a will is one of the things, one of the most important tools any person can use to make sure that they are planning their property well in case, the Bible says it is appointed for us to live and then to die. So when that time comes and you have property, then it's good to have that, all those issues around your property taken care of, so that when you pass on, or if you pass on, then your beneficiaries will not have a problem. They will not have a problem with what to do with the property. Like there will be no problems as to what will happen to it or who will get what. So it's all part of something called estate planning, and a will plays a very important part in that. So the will is basically a document that is provided for by the law. The law is called the Law of Succession Act, and it is whereby it's a written document that somebody writes to indicate how they would like their property to be handled when they pass on, and it also gives the option of having someone to oversee the will upon the death of the person writing the will.
Wow, thank you. Even listening to you, a lot of questions crop up of my mind about, okay, so then if it's a document, if I say it, does the law take it as a document? What makes it valid? What invalidates it? But we will come to that.
Yeah.
But maybe Ruth, you can tell us why is it important? Why should I have a will?
Okay, a will is definitely important. And basically, for me to decipher that question, why is it important? Because it's important. So we already agree that it's a very important document to write. So now, reasons being that you're given the freedom to be able to decide on how you want to distribute your property. Is it to your children, to your spouses, to your friends, to institutions? It's not limited. You can distribute your property as you will, because in the same way you obtain the property is the same freedom you get to dispose. So this is a term we use. We call it testamentary freedom, meaning that you have the freedom to write a will. And in fact, the Law of Succession Act actually allows even married women to write wills. Basically, the qualification is, are you over the age of 18? Do you have free property that you intend to dispose of? And are you also of sound mind? So you have to be of sound mind, you have to be over the age of 18, and you have to do it on your own free will without any coercion, undue influence. There's something we call importunity, or the will is not by fraud. So it just has to be something that, yes, you do willingly.
As you're describing that, telling us what it is, I think you've explained what it is, why it's important, and you've stamped the fact that we're starting at it is important. What then? Let's talk about the process that makes a will valid or invalid. What can you say? This is a valid will, this is not a valid will, especially formally. Yeah. And we can start with you, Dr. Jerry. I'm looking at you, sorry.
Yeah. Okay, so Eunice pointed out, I mentioned that the will has to be a document. It doesn't have to be a document. It can also be oral. But when you're looking at the issue of ensuring that a will is valid, then there are a few things you need to take into consideration. So number one, the person doing the will has to have the capacity. And by capacity, I mean they have to be able to write that will out of their own volition. They're not being forced, or they're not being tricked, or being misled. So they have to have the mental capacity to write the will. Then once they do that, then of course they have to be over 18 years old. Then they have to have property that now needs to be disposed of. And the will is now ensuring that the disposal is going to be undertaken now in the way that the will is going to say. Then the other important thing is the will has to be overseen it has to be witnessed by two people who again are people who are of sound mind, and who are not beneficiaries of the will. So those are some of the key things you need to look at when you are trying to understand when you're trying to do a will in a proper manner. Because the whole concept of estate planning, it's about removing uncertainties about how the property is going to be overseen when someone passes on.
Yeah.
So part of that process is ensuring you have a valid will.
Yeah.
Because if the will is invalid, it now even increases the uncertainty. Yeah.
You know, you've said, and this question goes to both of you, you've said that one of the caveats for a valid will is having the person writing, I think you call them the testator?
Yes.
Is that the testator?
The
Okay,
testator,
good.
yes.
I'm getting these legal terms. I feel so proud of myself. They have to be in the right state of mind.
Yes.
But we are aware of situations where people have property, but they are not in their right state of mind. So does that disqualify them from will writing, or what do you advise those people to do?
Okay. That's a very interesting question, because when you look at it from different perspectives, how did this person get property while of unsound mind? So I think when you ask such a question, you want to know, normally when you're drafting documents for conveyancing of properties and all that, we normally draft affidavits, and one of the paragraphs, in fact the first paragraphs of an affidavit is, I am so and so, an adult male or female of sound mind. So I'm just wondering which legal process can be used to generate title documents or basically ownership documents for somebody who's of unsound mind. In the circumstances, I would think it's probably a situation where you have someone who has intervals of lucidity, or what I would call intervals of being sober or normal, such that they've been able to acquire the property when they were of sound mind, but then again they have degenerated to a situation where they are not lucid.
Yes.
And then now the person has intends or want to dispose, but of course definitely they are not qualified to write a will in their, in their state of being of unsound mind. In the circumstances where you have someone who at one point had property and has now turned to be of unsound mind, then that property can definitely be distributed, but the law makes provisions for guardians of people of unsound mind. It makes provisions for ways to administer estates and all that of property, of estates of persons who have unsound. So definitely it's well provided for, but not the person himself. They have no capacity. Yeah.
So I'm thinking about a situation where the person temporarily gets sick, and you, let me borrow your word, so they have intervals where they are lucid. Would the law uphold them as of sound mind at that point, even though at the point, I'm assuming your question is, can someone contest on grounds that when I look at this person right now, they don't look well, but maybe at the point at which they wrote the will, they had an interval of normalcy. What can people use to support that interval, that they were okay at that point, even though right now they don't look okay? Is there something that the law provides for that?
Yeah, I think that now becomes a legal question, but it's also a medical question. So when now she has talked about issues of guardianship for somebody, so that can only apply to someone who is still alive. And the issue of guardianship and for someone who has not, who is not mentally competent, then there's a whole process under the law that is undertaken to actually arrive at that determination that this person is not of sound mind and that they need a guardian to oversee their property or their affairs. And that process will involve going to court, of course, but it will also involve speaking to medical experts who will now be able to make that determination. Because it's a medical condition, and an expert needs to weigh in on that. And then if there are some specific decisions that have been made by the person whose mental capacity is being challenged, then again, to understand whether he was lucid or whether he was sane at the time when he was making that decision, my opinion is, or he or she, my opinion is that, you'll need a medical doctor to make that determination. And that might be something that may need to be taken to court to be able to arrive at that decision.
You know, a question that, as we're discussing this, a question that probably if I may add more into my former question, it's, you've described we can have a situation of someone who acquired property when they were in the right state of mind, they were fine, and then of course life happens, and at some point things are not okay, they're not healthy, especially mentally. Is there a place, but has children or, you know, dependents that are aware will writing is important? Is there a place like we can have someone step in and help them through that process? Is there something like will writing on behalf of someone? And is that even legal? Is that even allowed for a person like that?
I think even looking at the word itself, will,
Yes.
it's like it already has that connotation of something that you're doing out of your own will. So I think if there's an incapacity in that area, if there's a problem with that person's will, and I think that's a will, even if it was done, I think it might be challenged.
I see.
Yeah,
I see.
it might be challenged, and who knows what the courts might decide. In my thinking, it might not be. I mean, you can do it, but I don't think if it is challenged, it will stand in court.
Okay. All right. Okay.
I want to go back a little to the definition again of will, because we said it's a document, but also can be oral. Do you mind to talk to us a little about the validity of an oral will?
Yes. So the ingredients of an oral will are similar to those of a written will. So the person making it has to have the capacity, and they're doing it out of their own free will, out of their own free volition. But it has to be witnessed. There has to be witnesses who will attest that they had the will being made. And we were discussing this a few minutes ago, and the person has to then pass on within a period of 3 months from the time they make the will. So then that would become a valid oral will. Yeah.
I see. Okay.
Yeah.
All right.
And Ruth, probably you have come across such where the person who has done the will is on their hospital bed, they do not have access to even a paper or a pen to write,
Even
what
the
are
ability.
other ways that validates that will? Because we're a society that is really big on signature. Like there can be a document, but it doesn't have my signature. What makes that will valid still?
Okay, I think I'll add on to what Council has said. I'll add an exception to oral wills being valid within the 3 months. The exception would be people in active service. I would say in maybe the army, they're in active service and they die while posted. Yes, and they're not able to, definitely the time lapses before that information is actually relayed. The mariners, we have exceptions, of course, to the rule of 3 months. But then again, you've asked the question about people who are sick in hospital beds and they cannot probably access a pen and paper to put down the whatever they want, or maybe they can't even do it because they're incapacitated. Probably they can't even lift their hands up, they can't even wake up, but they are in their proper mental faculties, and they actually want to write down a will. So a will by dictation is not an invalid will, it is a valid will. You can dictate whatever you want, of course, with the witnesses as required,
I see.
and definitely that will can be put down and validated as a written will. Yes.
I see. All right, thank you.
What is it called?
Stamp, something.
The
I don't even know what you want to say, but let me wait.
what is it called? The thumbprint. What is its validity?
The law even talks of signature or affixing their mark. So basically, that thumbprint is a mark. It's a mark, yes.
I see. Okay. All right. Let's talk about some of the loopholes, mistakes made around will writing. What are some of the comments you would make on that? What are some of the mistakes people make when they're writing wills? And I have a specific example. When it comes to customs and traditions, to what extent do they affect the way we write, especially in the Kenyan context, the way we write wills? Yeah.
I think, okay, before I answer your question, now that you've talked about tradition, I think one of the hindrances even to proper estate planning in Africa is this, I think, morbid fear that people have when issues of death are discussed. So that, in fact, becomes a huge stumbling block to wills even being written or estates being planned. So that's usually a problem. But for now, someone who has decided to do their will, and you find that one of the uniquenesses of being an African is, the communities we come from. And these communities, they come with a heritage. Sometimes it's a rich heritage. Sometimes it's a heritage that begins to conflict with our current laws and our current understanding of how things like fairness and equity operate. So you might find that maybe there's a man who is from a community where women have not been allowed to inherit and this is something going back years. It's not something that has started now. And then you find that under the current Kenyan law, it is there's a phrase in the law for laws that are not obnoxious. Anyway, there's a you find that under Kenyan law, we do not allow that. We have changed that culture under our law so that women can inherit property. So a culture that like that now can make someone write a will that is then, even though it has followed all the proper procedures, you know, it has witnesses, the witnesses
yeah,
were okay.
yeah.
It has followed all the right procedures, but because it is because the essence of the will be doing something that is in opposition to our law, then such a will
Yeah.
becomes invalid.
So it is invalid.
It
All right.
it will be invalid, and if it is challenged, it will be invalid. But I think, if it is challenged, it will become invalid. Yeah.
Okay, so you're saying the daughters from this family, from the deceased, have the right to go and contest in court.
Yes.
And you're saying if they go, they have a case according to the Kenyan law.
Yes. They
Beautiful.
have
Yeah.
a right, and I think they should. And again, we were discussing this a few minutes ago. People should not feel like they are doing something bad, like they are doing something that I don't know, tradition frowns on, or no. I think we should embrace some of these rights that we have, and just seek to enforce them. Yeah, even if it means going against something that we have been doing for many years as a people.
Yeah, I think it's you, Ruth, was saying earlier, you've had situations where ladies come and tell you, you tell them they have a right to go and contest, and they say, no, I'm fine, I don't want to fight, I'm okay with that.
Yeah, yes, that's true. And I'm even happy that Wakili here is a gentleman, and he's actually rubber stamping the law. And that's the beauty of the law, because the beauty of the law talks about non-discrimination. Especially the Constitution of Kenya, the 2010 Constitution, it was like it was like a breeze. What do we call it? Fresh air.
A breath of fresh air.
A breath of
fresh air.
Yes, a breath of fresh air into some laws, some practices that sometimes could not be considered really fair or impartial. Women definitely should be open to the idea that the law has changed. Yes, in the past, it was what it was. Women were not allowed to even inherit, I've done a case where it was obvious. That was the law by then, A woman was not entitled to anything. It's actually, if there was anything to be given to her from her husband, it went to her firstborn son to hold in trust for the other siblings. And those other siblings are the boys. The girls are nowhere to be seen. So definitely the fact that I can even sit down here as an advocate tells you that women have taken strides towards empowerment. They've taken strides towards fighting for some recognition, because even by then I think it was difficult even for a woman to address a council of elders, a council of men. So we cannot do away with some of those traditions and insist on keeping some that are very retrogressive, because that's what we call retrogressive, because women inheritance is retrogressive, is as retrogressive as FGM, So definitely, women are entitled, and they should not feel embarrassed to fight for their own inheritance, because it is what it is. Everyone has accepted it. The law has put it there. So fight for your rights. If you don't, unfortunately, you'll be the loser.
Yeah. Thank you, Ruth.
And
you
you
sound very
see-
passionate.
I know. And
It's a very passionate
interesting,
point,
I'm listening to Ruth and I'm thinking, would I go and just allow my father to know that I'm about to go to court the moment he dies, because he hasn't bequeathed me something? There's a lot of detox that we have to do for the culture. We have to detox our culture. Some of those things that you're talking about that are of no benefit to the society and are certainly not of any benefit to the women. So yeah, girls out there, you've had. You are entitled.
I think there's a story in the Bible where some ladies, some sisters, went to Moses, and I think their father had passed on, and I think they wanted to inherit
Yes.
his property.
Yes.
And Moses, as a chief judge, he made a ruling in their favor. So this again is it's not something new, and especially for us in the household of faith. Then I think what we have done is we are, she has said, bringing in fresh air, but also applying principles that even the Bible itself in the Old Testament has upheld.
And you know
the
there are-
daughters of Zelophehad. I think that was the name.
okay.
Yeah.
But Pastor Charles quoted some fathers were with it long time ago, and he named Job.
Even Job.
Job
Job's
bequeathed
daughters. Yeah.
Inheritance to his daughters. So we're gradually catching up.
Yes,
Yeah,
we are.
yeah.
That's a good thing. All right. Let's talk about well-writing, inheritance, and children born out of wedlock. What does the law state? What does it say in regards to that?
Okay. Ruth has already mentioned that concept of non-discrimination. So you can't discriminate against your children
Yeah.
just because they are born out of wedlock. Yeah. If their father has or their mother has property, then they have a right to that property. And even if a will is made, and the sole reason why they were not incorporated there is because maybe they were born maybe through another woman or another house, as we say in Kenya, then I think that's a decision that is against public policy, and such a will is going to be invalidated. So if someone has children, when they are doing their estate planning, they need to plan with their minds, including all their children.
Yeah.
Yes.
Yeah.
Yes. Even if they have children with different people, then those children have to be incorporated
Have to
into
be
the estate
incorporated as
planning.
well.
Yes.
Okay. All right.
But I'm wondering about a situation where a person like is 50 years, they've never been found, but they appear at death. What would the law require for them to ascertain that they are indeed a child to this deceased man? Because then the whole world would as well appear and say, this was my father.
Actually, that's a very nice question because it reminds me of someone that I saw charged in a law court. I can't remember exactly which law courts, but there was a very wealthy man who passed on and left so much property, but he had no dependents, no heirs. So this guy actually forged his birth certificates, put the name of the deceased, and came to inherit. He actually petitioned for inheritance. It was only later that it was found out that there was no surviving child or beneficiary of this deceased person. And he actually had to go to the dock and take plea for what he had done. So, yes. The question again?
Yeah, I asked if there's, so the same thing you've said.
Yes.
The person is, say,
Yes.
50,
Yes,
but
so
he has never appeared anywhere.
Yes, exactly. So I was coming to that point. So yes, people can be opportunistic, if that's the word. And yeah, people will try to take such opportunities. And in fact, I always say that the place or the forum that we find the most properties being even, distributed illegally or even fraudulently is a succession forum, because you'll find so many cases in our Kenyan courts today are on revocation of grant, meaning that there was some kind of fraud or somebody deciding what they want the court to know and what the court should not know, and what the person is not telling the court is actually material to the court being able to administer or conduct that succession in an open and fair manner. So most of the times people will petition and of course leave out others. On this question of the 50-year gap, and someone has just appeared at the burial to claim inheritance, I would answer that in one way. Is this person a child of the deceased person? Because if you are a child, then you do not need to prove dependency, if that's what you wanted to know. But if you're not a child, you are just someone who has appeared from nowhere, and you have no relation at all to this deceased person, then on what basis would you be asking to inherit from his estate? Unless, of course, you can prove dependency. How can you prove dependency? Was he paying your school fees? Was he sending you maintenance? Were you directly benefiting from him? Yes? You see, those are the kind of the situations that you would find.
Yeah, all right. Thank you. Thank you. Thank you so much for sharing. We already headed to our first break. Okay, our break actually. We just have one break. Yeah. So take a short break. We'll be right back.
God of Abraham, you're the God of covenant and of faithful promises. Time and time again, you have proven you'll do just what you said. Though the storms may come and the winds may blow, I remain steadfast. And let my heart learn, when you speak a word, it will come to pass. Great is your faithfulness to me. Great is your faithfulness to me. From the rising sun to the setting same, I will praise your name. Great is your faithfulness to me. God, from age to age, though the earth may pass away, your word remains the same. Yeah, your history can prove there's nothing you can't do. You're faithful and true. Though the storms may come and the winds may blow, I remain steadfast. And let my heart learn, when you speak a word, it will come to pass. Great is your faithfulness to me. Great is your faithfulness to me. From the rising sun to the setting same, I will praise your name. Great is your faithfulness to me. I put my faith in Jesus, my anchor to the ground, my hope and firm foundation. He'll never let me down. I put my faith in Jesus, my anchor to the ground, my hope and firm foundation. He'll never let me down. I still bless you in the middle of my storm, in the middle of my trial. I still bless you. I still bless you. I still bless you in the middle of the storm, in the middle of my trials. I still bless you. I still bless you. And I'll testify of the battles you won. How you were my portion when there wasn't enough. I'll sing a song of the seas that we crossed, the waters you parted, the ways that I walked. Hupimwi kwa siku, hupimwi kwa miaka, unatafsiri majira, huzuiwi na muda, umejawa na nguvu, ndiyo maana nakuita Baba. Moyoni mwangu najawa sifa na ujasiri katika wewe. Hakuna mlima wa kuniangusha, ndani yako ninasimama. Misitekete, siangamii, sigarikishwi, upo nami. Misitekete, siangamii, sigarikishwi, upo nami. Nimezungukwa nawe kila pande, hakuna jambo la kuniangamiza. Majeshi yalo upande wangu ni mengi sana kuliko hawa dunia. Hatua zangu zaongozwa nawe, siangamii.
Welcome back from the break as we continue the conversation on will writing. I'd first of all like to say hi to a few people that are joining us this afternoon. I see Charity Moragatimu, I see Eric Mulwa, Kevin Mwao, Gikonyo Emma, and then Eric Mulwa is saying very helpful conversations. And then we have Isaac Murage saying great conversation. And then he goes ahead to tell us about the daughters of Zelophehad that we're talking about in the Bible. He gives us the names. They were 5 sisters. We had Mala, Noah, Hogla, Milcah, and Tarza. I hope I mentioned them right. And he says they are mentioned in the Hebrew Bible, and it's found in Numbers 27. So validating what you've talked about when it comes to women inheriting property, the Bible does affirm that, yes.
You can go on.
Okay,
You have to
sawa.
look at the camera and say thank you to Isaac. That's a lot of work. The Reverend has worked. Mwambie
Thank you
asante.
so much. I have been instructed to look at you and thank you. Asante sana for helping us know where it is found in the scripture. And asanteni sana for joining the conversation. As usual, you make this exciting. Yes.
Nataka kusalimia Eric.
Haya, wasalimie wote.
Habari Eric. Thank you so much for joining us all the way from City Campus.
Karibuni. Your moment of fame. Yes. There it is. Sawa, sawa. Asante sana.
Anyway, before we took the break, we talked about validity of the will. We've talked about many things. I even need to go somewhere and sit down and just take it all in, you know, and be thankful because I have learned some complex words from the council here.
Yeah.
But as we talk about validity, I'm wondering where the place of come we stay marriage is.
Are they rightful inheritors? Are
Now
they
that
rightful?
we are talking about valid, the
Yes.
word here has been valid.
Valid all
and then we are
along.
thinking about this wife who
Yes.
the society thinks is not valid.
Yeah.
Where are they when it comes to will? If a man has put them in the will, are they rightful owners?
Yeah.
And
And if he hasn't, does this person have a right to go and, let's say in a case where the will writer dies, passes on, does this person have a case in court when it's a come-stay marriage situation?
and
Yeah.
what case could that person take that validates all those years alikaa hapo akapika akaosha
Okay, yeah.
So, as they say in social media, it's complicated. It's a complicated relationship, that one. But I think, so for Come We Stay, let me start by answering backwards. If you are married, and you have a marriage certificate, so that certificate is a conclusive evidence that you are married. So if somebody challenges your marriage and you have the certificate, that question dies there. So Come We Stay, the challenge now is that there's no certificate. There's no official recognition from the government that there is a marriage. So if a will is disputed, challenging, and the ground of dispute is that these people are not married, then in my thinking, you may need to first prove that the marriage existed. Yeah. So as you're saying, you now bring in those things that can.
Tembee na watoto wangu
Yes.
hapo.
So now.
And they have a forehead like for the father.
Yes. Yeah, wanangorota kame, or they drool like him. So you need to come and prove that this marriage existed. Yeah. So, but my thinking, if someone already has children, I think even the person disputing is.
But there are
By the way,
situations
Yeah,
where
yeah.
there are no children,
It's
though.
true.
Yeah, if there are no
situations
children.
when there are no
yeah.
children, and I've lived in that house for 5
Yeah,
years. And I don't know why we are making the assumption that it's the lady and it could be the other way. I don't know.
Yes.
What's the place
Yeah.
for lapse of time, Ruth?
I think to add on what Council has said, we have the Marriage Act 2014. It just almost validated cohabitation marriages, because at one point when it was at the public participation stage, there was that provision that said when you stay with someone for more than 6 months, then there's a presumption of marriage. Well, that was basically putting a timeline within which a marriage by cohabitation can be presumed by a court of law. But it was not, that law on cohabitation being presumed to be marriage has always been there. It's common law. It says that where you have, you are known, you are married by repute. It means you have been together, your neighbors know you are married, probably the area chief knows you're married, everybody knows you're married. So they're even surprised there's no certificate because they all know you're married. So that's what we call marriage by cohabitation, which normally comes up from a position of repute where everyone in your area, because you don't live in seclusion, you live in a society. So definitely there will be a presumption of marriage. And it's now up to the courts, upon your presentation of whatever you have, to actually establish that there is a marriage by cohabitation. Normally, in such circumstances, people go to court for a declaration that there was a marriage. I've had people ask questions such as, I cohabited with this woman for 10 years, 15 years. We have 3 children, but we have no marriage certificate.
Yeah.
And we are no longer together. We need to do a divorce. So someone asks you for a divorce, in a marriage by cohabitation. So the position normally is what you should have done earlier, but anyway, if that's the situation right now, you will tell this person, we need to go to court, we need to get a declaration of marriage, then we need to get another order for dissolution. Yes. So the court will have to first establish that there was a marriage and give such a declaration. And then it will go again and dissolve that union.
Yeah.
And that acts as a divorce.
Yeah, so I'm curious.
Yeah.
The court has to first go ahead and see that there was a marriage.
Yes.
So in this case, now that there's no marriage certificate to show that we were married, we were together, what will they use as evidence to prove that they were married? Is it the chief you're mentioning,
Exactly.
the neighbors?
That's what we call
So they are valid enough?
The reputation. That's reputation. So we will call your neighbors, your next door neighbor who was there when you
What
met.
if I bribe them to come and...
And unfortunately, that's not an option unless whoever says you've bribed can prove. So you basically have to have evidence of persons coming in and saying, yes, I know so and so, they were my neighbors. In fact, you can even have your house girl who probably resided in the same house as the both of you and knew that you are both husband and wife. The chief will probably come and say, I have always known them to be husband and wife. In fact, they have attended all my functions and I have even probably officiated some of their functions, you know. And then, of course, children, when the more the children, of course, the more persuasive it is. Because most men, I don't know what happens, when there's no certificate, they take it as an opportunity to escape the responsibility and say that, no, I've not married this woman. She's not my wife. That will be subject to vetting by courts.
I see, I see.
Jasmine, I think this is your, what did you call it? Your... Sikumbuki vile uliniambia, but let's just wear your reverend hat. Yes.
It's on.
It's on. Talk to the girls who their mind is beginning to tell them, nasikilia huu kijana huruma, why are we paying 2 rents? Kuna COVID. No, kuna COVID. Hii pesa tunaweza tumia, we can save, we can open a joint account. Let me save him, or let me save my rent by going to him. And I know he loves God. He has promised me he will marry me. Talk to them. So that, tuondoe maneno ya complication. The council has talked about a complicated...
A complication?
Yes.
That we have to prove our marriage by repute. Why do we have to go through that? Yeah, I think you know, it's interesting. That's a conversation we had last week. There's another show that we have that's called Homescapes. And that happened to be one of the topics we talked about, one of the questions we discussed last week, saying, I think probably most of the times when you get to that situation feeling like, why are we paying? You know, I love him, he's a good guy, he's a Christian. Why are we paying 2 rents when we can easily just move in together? I think sometimes people work from fear of how weddings have been made to look like. They have to be costly, they have to be expensive. They have, you know, you have to sell an arm and a leg for us to afford this marriage. Yet church has provided a very easy opportunity. Come bring a few people, pastors, to pray over you so that you do this before God and before people. And it's easy, and then continue with life so that, and then after that, you'll get your marriage certificate, you know. You're before the eyes of God and of men and even of the state, you know, Kenyan law, you are recognized as people who are married. So it doesn't have to be super complicated. To avoid these issues that we are hearing here, let's do things the right way, you know, the right easy way that has been provided. Yes. Yes. I think we'll throw in another question to ask guys when we're talking about some of the mistakes or things people miss out on when they are writing wills. Let's talk about the place of an executor. I was about to say the word I said before, executioner. I don't know why it's in my head all this time. But I know it's executor. Can we probably, first of all, even define, when it comes to the story of the will, this topic of will writing, who is an executor? where's their place, and in will writing, if they are not present, if they are not mentioned, does that make that will invalid? Yeah.
So one of the questions to answer when you're doing your estate planning is who do I trust to handle my financial affairs and to take care of my property in the way I would want it to be handled when I'm not around. So that person now, when you get that name, ideally that person now becomes your executor. And that's a person now who will do exactly like that. They'll just oversee the provisions of your will and ensure that if it's property, it goes to the people you have willed for them to get the property. So that's the executor.
I see.
Yeah.
I see. So a question, you're saying it's a person who will oversee the process of ensuring that the inheritance and the property go to the right people. Can that person be can that person be a beneficiary, a person mentioned in the will? Can they qualify to be an executioner?
No.
No.
No, the executor should be objective and independent, like the witnesses. Yeah.
I see. So, and in places where this executor is not mentioned in a will, what happens in that scenario? Does that will become invalid?
I think if the fact that a will has not mentioned an executor should not invalidate a will.
Okay.
Because I said should. Yes, because that is an administrative issue. It's an issue of who will do like I want to be done, It's not about how do I want to distribute. So it would be seriously wrong for any court to invalidate a will on the basis of a lack of an executor. But that being said, yes, a will is as valid as the formal validity being complied with. And basically, if the executor has not been mentioned, the court will go out of its way to appoint an executor.
Okay.
Yes, upon petitioning. If the will does not have an executor, someone can petition to be made an executor of a will without an executor. Or in the alternative, the court itself can on its own motion, or what we call suo motu, appoint the executor of that will. Yes.
I see.
Yeah.
Okay. Wow.
Yeah, but it's good to have an executor because, if the will is about your intentions for your property, then it's best to have someone whom you are sure and are confident is going to do what you want done with your property. Yeah. For me, not having an executor somewhat beats the purpose of writing a will.
Yeah. So for someone who's preparing to write a will, what's your advice when it comes to the question of choosing an executor? What should they look out for? Is it a person who has achieved A, B, C, D? When it comes academic-wise, is it someone you trust and you feel like and relate? What's the process like?
The qualifications of an executor. Most of the times, you'll find people have close confidence, people who know what they're doing, and someone will say, I would entrust my property with so-and-so to administer it, as I have said. So most of the times, you'll find testators going for their very close friends, confidants, but there's really no qualification.
I see.
The only qualification is, can you be able to do it? Can you be able to interpret this will and be able to do like I said? Yes. Again, the only probably, I think it's important to say it here, it will be very important to know that this executor is capable. By saying that, I mean the person is not of unsound mind again. Yeah, this person has to be of sound mind and very capable of executing that will. Yes.
I see.
And over the age of 18 again. You can't
okay,
go for
yes.
a minor and someone who does not know.
By the way, I'm thinking about a situation where, because a lot of time we make decisions, we put things in writing and forget. And I imagine when people are in college or in university, you ask, when is the right time to do a will? And they say, just write a will. So you've left university or college, you've worked hard, you have property, and you've done a will. And you've tucked it in somewhere. You'll tell us where it should be tucked in. But then, and you get married, you have children. But then along the way, unfortunately, the person dies. So there is a will, but you did the will before you got married. What happens in that situation?
I think, so for wills done before marriage, I think the law says that marriage is going to invalidate that will unless the will had anticipated the marriage. Yeah, so if it didn't anticipate the marriage, then that will is going to be invalid.
All right.
Tell us about the invalidity. So then you have this family and you have whoever you had indicated as the beneficiary.
As a beneficiary.
Yeah. So then the invalidation means the person who takes the day is the person who had been indicated, or your family, your current family.
So invalidation means that this person is now declared to have died without having a will.
Okay.
And then now another section of the law of succession takes over to oversee the administration of that property. So in the law, the word used is intestate succession. So that means that somebody has died, they didn't leave a will, so now there's a whole process that now needs to be undertaken before anything can be done with the property of the person who has passed on. Yeah, and it now becomes a whole new, it's something where now the family or the beneficiaries, of course including the family, have to sit down and agree who amongst them is going to be the administrator. And the administrator can be more than one person. Then they have to go to court and make an application for this person or these persons to be made the administrator or the administrators. And then the court, so you have to file a claim in court, an application in court. It has to go before a judge, and the judge has to hear evidence, and then an order is going to be made confirming that the people who have been agreed upon by the family or by the beneficiaries are now the administrators. And then now the administrator will be given the power by the court to oversee the distribution of the property of the person who has died. But whatever they do has to be for the benefit of the beneficiaries.
I see, right. Thank you. Thank you for sharing. I have another question. When is the best time to start writing a will? What age? What season? What experience do I need to start writing a will?
I think from the time somebody is 18 years old, that's the age of legal capacity in Kenya. So you can write a will, and if you have property. Yeah. If you have no property, can you? I don't think you can write a will. It will be I mean, you can write something called a will, but I don't think it will be.
I probably
of
have
any
my
effect.
precious phone here.
And my jewelry.
Yeah, do you have an addition to that on when the best time is?
I would be able to answer that question with another one. Like, is death predictable? That's how I would want to approach that question, because when is the best time depends on when you will die. Do you know when you will die? It's not predictable. So, like Council has said, immediately you're qualified to write a will, then that becomes the best time to think of having a will just in case you pass on. I think the other thing that I think we didn't really delve into was the issue of when wills become effective. Because a will is not effective when you're alive. It's a will, yes, but it's not as effective now when you're still here, because you can always change it. You can, go back and say, I'm not comfortable with what I said. I want to give so and so this and that. So that's why we say you can revoke a will that you've already written after you have a change of heart, and you can revoke it by another will. That's a codicil. Or you can do, you can do a codicil and amend whatever is in the other will.
Ruth,
Yes.
please break down the term for us.
Oh,
That
a
codicil.
codicil is an additional, it's another will that is to add on to a will
What you
that
had
you've
already
done.
written
Yes.
before.
Yes.
Probably I acquired more property
Yes.
and I decided I'm gonna,
Yes.
include. Okay, I see.
Yes.
All right.
So, since you can always amend whatever is there, then, that still falls within your testamentary freedom. Nobody forces you that if you've written this will, you will not change it.
I see.
No.
I see.
You have the option of changing, revoking, doing whatever you want, adding more properties or not. You have all that. You can decide to sell property now and realize you had put it in your will. You can amend that will and do away with the property because when we talk of wills, we talk of free property. So that property should not be encumbered. By encumbrances, I mean it's subject to someone else's superior rights.
Yeah. Thank you.
Yeah.
And lastly, where do you store your will? Do you even store a will, or do you keep it, or do you save it?
Yeah, you have to find a safe place to keep the will. So, in fact, I'm even thinking you can make a will and maybe keep one, maybe in your safe. Your lawyer could have another copy. Yeah. So, and then you could keep a copy in the bank. Yeah, but for the will to be effective, it's good for someone to know that the will exists, so that when somebody passes on, then it becomes the natural thing now is to read the will. But if people don't know that there's a will, then it becomes another challenge altogether. Yeah.
I can add to what Council has said. We also have the public trustee, and you can actually deposit your wills at the public trustee, and they have a register of wills. So all wills that are deposited are registered, and they are not opened until, of course, yes. And the public trustee can also administer. Yes.
All right. Okay. Have any addition to make? A question?
Okay, I just have one final question. One final question. I'm thinking about the way sometimes we've had stories of people visiting their old parents in the hospital and saying, he signed here. And so because he signed here, this is my property. How does that become legal or not legal?
Yeah, so I think we've mentioned that the will has to be voluntary. It has to be made out of a person's free will. So if there's any undue influence or any coercion or pressure for the person to apportion property to a particular person, then that automatically invalidates the will. Unfortunately now, if it's done in private and no one sees it, or it can become difficult to prove the coercion. But the person doing that should know that that is illegal, and it's not an acceptable thing to do.
Wow, thank you so much. Thank you. We are grateful, Jerry and Ruth, for giving of your time to enrich us with your wisdom. We definitely are wiser and we know much more. And I will hold someone accountable because they say they have a phone to put as number one to their will. But yeah, I know the congregation members have really, really gained a lot. This in itself is meant to be a paid session where you go to seek a lawyer and you pay something. So we're thankful that you would give of your time, and we pray that the Lord would bless you in excess of the sacrifices that you have made to spend the afternoon with us. We are thankful.
And asanteni sana to our online community. You're coming to the end of the show. Thank you for joining us. We pray that you'll have a very blessed week.